I hope the recording is on.
Yes, it is.
Okay, great. Thank you again. And thanks to our expert speaker. So just to give you everyone a background, I have created a PPT, which is just 3 slides. Let me share that. So to set the background of a discussion, the Court of Justice of the European Union published in 16 July 2020 its highly anticipated judgment in Data Protection Commissioner versus Facebook Island Max Schrems. The CJEU declared the European Union US Privacy Shield decision as invalid and upheld the use of the standard contractual clauses as the transfer mechanism of choice with certain restriction that you can see in this this PPT, which I picked up from IAPP. The European Data Protection Board announced in November 2020 that it has adopted recommendations on measures that supplement transfer tools to ensure compliance with the European Union level of protection of personal data and recommendations of the European Essential Guarantee for Surveillance measure during the 41st plenary session. Following this, the EDPB adopted very recently on 18th June 2021 a final version of the recommendation on measures that supplement transfer tools to ensure compliance with the European Union protection of personal data. So the European Commission's new SECs that were adopted recently has now provided organization currently using the old version and 18 months transition period to update their contracts. With this background, on the new SEC and the Schrems 2 judgment, my first question is to Jaipat. 1 year after Schrems 2, there has been convergence between Europe and US on, have there been any such convergence on processing of personal data? And how is the data transfer taking place in these two countries?
Hello, everybody. Good to be with you all. Aannaaand, Rajesh, Ritesh, of course, Kavitha, always good to see you. Has there been convergence? The authorities from both sides, the Department of Commerce Secretary, European Commissioner for Justice, they met a few months ago here in the US, and they said that they have resolved to intensify their negotiations for an enhanced privacy shield. So we had safe harbor, we had privacy shield, and now we are talking about a new or enhanced privacy shield. So I guess Humpty Dumpty sat on a wall. Humpty Dumpty had a great fall, and Humpty Dumpty is now again sought to be put back on the wall. So that's the stated position from both the sides. One of the issues that is somewhat recurring is that European Union surveillance is not a subject for the European Union. The European Commission, like any other government, understands that each member state does its own surveillance, and in some cases, very aggressive surveillance. So at the US and European Union Commission level, there is considerable recognition that surveillance is here and is not going away. But at the way GDPR is written, the way fundamental rights are written, there is clearly a disconnect between how the Court of Justice looks at these issues. And it talks about equivalence, but there is considerable surveillance within member states as well. So there are some very serious differences. So there is convergence and then there is divergence as well.
Very interesting.
To your second part of that question about how's data transfer taking place right now? Um, First of all, GDPR is about transfer of personal data. It is not transfer of data. So data transfer is taking place, which is not necessarily personal without being subject to GDPR. The second thing is that uh, that standard contractual clauses were accepted mode of transfer. And now we have new fortified I guess, enhanced versions of standard contractual clauses and more choices in standard contractual clauses, more pinpointed modules are available. So the vast majority of transfer is taking place under those today. And the guidelines that have come are going to be helpful. And within the last 1 year, I think we have matured in our use of standard contractual clauses anyway, even before the new ones came. So that is principally the way in which transfer is currently taking place. BCR does exist and large corporations have chosen to go that route, but it is not exactly the most popular way of doing things, especially for smaller businesses.
Thanks.
Does that answer your question, Kavitha?
Very well, Jaipat. Very interesting, especially on the conversions and diversion that's taking place. With this, I just want to understand how are organizations now expected to prepare for the compliance under the Schrems 2 ruling? And I think I would like to know from Aannaaand, the final recommendation, as you rightly said, has outlined a 6-step roadmap to assist the assessment of third company. Can we go through the 6-step phrases that has been laid down in the guidelines that is released by EDPB? I did found it, I have a slide on that, but I wanted Aannaaand to share the realities on ground. How are we going to comply with the 6-step guidelines?
Yeah, trust me, Kavitha, it's a very kind of a tricky and very complex question when it comes to the practicality and reality to do that. One of the big change which this particular steps have brought down when you come to the first step where you know your transfer, where they expect that the data which is moving, specifically personal data, which is moving out of your organization when you export it, not only goes in which country of the the processor, but also further to the sub processor, right? And with that, you have to have your data mapping program to be extended and made more stricter, your classification of information to be stricter. It has significant impact on your records of processing activity. So that is one of the very big step that, which is taken by the know your transfer kind of a step. Secondly, coming back, like Jaipat said just now, I'll just kind of repeat what he said. There are organizations who are relying on, your standard contractual clauses, your BCR, some of them go with the code of conduct, some certification mechanism come into picture. And then you have the ad hoc contractual clauses where more focus is imposed on the technical aspect as to how you're going to protect that data, right? Because that is something which is more important, because not every country in as of now has kind of achieved the adequacy test with respect to EDPB for that matter. So this is something which is very, very important to make sure that the tools on which you are relying on are adequate. This is still, I would say, a safer side. The most important and very tricky, which I feel in my personal capacity, is the next step where you have the assessment to be done, right? So the EDPB expect that the country to which I'm going to export my data, if it is a third country, say US or any other country, Australia or say Singapore or India for that matter, I need to check whether the country has adequate laws, and I have to keep that record of my assessment. Again, this has to be a risk-based approach, like I said. And it is very tricky that how do you assess that? Because there may be no surveillance, there may be surveillance. Government organizations may come and ask the organizations, depending upon type of data they are processing, hey, I need this data. right? I'm sure Ritesh in his conversation will add more to it from a technical angle, that when the government comes to the organization and ask what kind of data, but this is very tricky. And then how the organization defend that. So what has been identified through the Schrems, that when government makes such a request, it is very difficult for the local organization to deny that particular thing. And that's why that if the adequacy test is not passed or the law is not equivalent, the more focus is given on the next step of making the security terms in a very stringent way. Right? Typically, they rely on the encryption, pseudonymization, data minimization for that matter. And then there's a specific caveat to that. When you rely on encryption, the EDPB says that the encryption key should be with the exporter, not the importer at that point of time, so that they know when to allow someone to have clear access. Technically speaking, within that particular function, you have to have also the access control mapping. Who needs access and why he needs access for a clear text data. That's very tricky. And for that, every time you have to do an assessment and document that assessment, because tomorrow if the data protection authority or super authority comes to you and asks you that what is the basis of providing this access, you should be able to demonstrate. The most important part of this is that, the accountability earlier when GDPR came in, it was more on a controller. Then it shifted to controller and processor. And now both are accountable for these assessments, not only on the compliance perspective, but from a technical and risk perspective also, as to when the sub processor, when you do a sub processing function to any other vendor for processing the personal data, you have to understand or you have to notify that where is the sub processor further outsourcing the data, or is going to outsource that data or process that data in which jurisdiction, because the adequacy decision or the uh, adequacy test will be confirmed from a risk-based perspective over there. So this is something which is very important. And then then even if we have SECs, we have binding corporate rules, they belong or they bind specifically only to the organizations per se. They do not bind the government organizations, which is a bigger picture over here. So you have to make sure that you kind of mention at least the contract in the contract, that whenever such thing comes in, there is a reporting requirement to the controller, right? Further, you can add some ad hoc clauses to make sure that your security terms are incorporated to that extent. And then the last step where I would quickly throw a light is to evaluate. So the audit or the monitoring thing which is required, whenever a data is going outside, you have to monitor annually. So from a compliance or privacy compliance program, or selecting a framework, or negotiating a particular contract, these are some things which you have to keep in mind and document it in such an extent where you are transparent, because ultimately data subject is the in focus, right? And your liability lies on that. So there are no exemptions on Article 82 there, at least, even though Schrems comes into picture. But again, more responsibility, more accountability is coming over here.
So what I understand, Aannaaand, is this new step roadmap is bringing more accountability and more enhancement of compliances. The compliances have become more stringent, and it is just not for the controller, but even for the processor. And I was just wondering, how would this now impact outsourcing company, especially when the major outsourcing provider in the European market is $45 billion potential, and how it would impact in India. So maybe Rajesh, can you just throw some insights on the impact to the outsourcing companies?
So thanks, Kavitha. So thanks, Leela, and thanks others for this opportunity. I'm good to see you all here. So, Kavitha, to answer to your question, how does it impact India? And the baseline, first important thing is India is not one of the 14 adequate countries, which has been approved by the European Union. So, as a third country destination, one of the major service providers where we do have operations, from India, serving most of the clients in Europe. This definitely is going to have a huge impact. Second, the other type of legal instruments like BCR, which normally organizations proposes, and something which is in a better way of an approach in order to handle cross-border data transfers. That also, if you see, most of the Indian companies are not on the top 200 list. I'm sure Jaipat, Aannaaand, and Ritesh would totally agree to that. Because of the rigorous administrative process, where when an organization applies and gets to pass through a major of the administrative processes that is laid out, it's almost that most of the entities don't find it, and the cost is also absurdly high. Now, coming apart from that, as Mr. Jaipat very clearly said, that it's just the personal data it's all about. Now, in any other service providing where you see data which is just incidental in nature, or anything that is being providing where we do an application management support or any kind of infrastructure kind of a support, the risk is much the minimal because access is managed through most of the it's just one of the supplementary guideline case scenario 7, if you look at, is more on the remote desktop Citrix connectivity. So data doesn't come to locally in India, so we don't see much challenge. But when you look at outsourcing, specifically where you provide call center, voice center support, you provide ticketing, L1, L2s, help desk support, it's a huge impact, because in order for you to serve the client, you need to know to whom you are talking. You need to know exactly the individual to whom the processing is done. And the technologies that have been is still in the evolving stage, whereas what we call as, from a technical standpoint, we call it as a PET, which is called as privacy enhancing technologies. So it is not absolutely foolproof, which can really facilitate. And specifically when you talk from outsourcing industry, uh, these supplementary measures that may be sought by the European Commission, the cost perspective is on the much on the higher side. Okay, this definitely is going to impact major outsourcing service providers in India. So this is also one of the biggest impact. Then, if you look at one of the biggest thing that you can't avoid it is major cloud service providers and vendors are US centric organizations. And the whole Schrems 2 is more about initiated procedures against data being to US due to their surveillance mechanism. So ultimately, what happens is when you use any service providers, let it be Microsoft Azure or it would be Amazon's or a Salesforce, or you talk about SAP or ServiceNow, any platform you talk, US uh, tag is already attached to, and most of our outsourcing companies are aligned, and as organizations go on a digital transformation mode, we have some kind of a sync where it is the extended enterprise of the Indian outsourcing companies has some kind of US conglomerate part and parcel of that. So definitely that is also one of the major case where you will see definitely a huge increase. So as an overall, it's about the cost, it's about our extended enterprise partners, and it is about our adequacy. So these are some of the factors which definitely I would say, would create a substantial amount of burden on the outsourcing companies in order to explore and showcase or demonstrate those accountabilities that are laid out in meeting the compliance requirement. And last but not the least, one of the biggest concern is about data breaches, and that's also one of the significant effect based on the culture of employees who manage these kinds of data in a very as a kind of cautious and responsible manner. So that is also one of the biggest facts, and based on several researches carried out, seems to be as a low kind of a value where it may support you in terms of how the scrims or how this SEC is going to impact. So these are some of the challenges which the outsourcing industry definitely has, and this will definitely is increased with this new scrims 2 violation.
Thanks, Rajesh. I think this brings to my next questions on surveillance law. I have one final PPT on it. Let me showcase this one. This is a very interesting heat map that I picked up from Baker McKenzie on the comparison of surveillance laws in various countries on the liability of the companies disclosing the data to the government without sufficient legal base. So during the proceedings, we observed that CJEU found that the protection of personal law had limitation due to the domestic law, which Jaipat just mentioned like the domestic law in the US, as well as the access and use by the US public authorities of the personal data that is transferred to the Europe. Ritesh, my next question is to you. Being an expert in investigation and data protection breaches, if you can share some insights on the scope of the government surveillance in India. Over to you, Ritesh.
Thanks, Kavitha, and thanks, Legal Era. Kavitha, I think we are doing injustice to the sponsor. We are not able to see that screen. So you might want to just stop sharing the screen.
Yeah, this was my last final slide that I had. Yeah, after that I will stop it. Sorry about this project. I never knew about it. Thanks anyway.
Okay, it's okay. You've shown India as red, which says that our companies are liable to data subjects if they disclose data to the government without sufficient legal basis. Somewhere I think this should have been green, the way it's in China, I guess. I doubt it really works over here.
Okay, so yeah, red is actually yes, and green is no.
Oh, okay. So it's the
other way around.
Yeah, it's the other way around, and we are legends. Okay, cool.
Right.
Yeah. Okay. Okay. So Kavitha, how it is now? I mean, as far as the surveillance in India is concerned, I mean, I'm not a legal person. I don't come from the law background, but I know, there is the Telegraph Act, and on which I don't want to talk about it because I don't know about it. And then there is our Interception Act. I mean, the IT Act 2000, 2009, in fact, and it is about lawful interception. So we have that as section 69(2) in India. And it actually, a few years back, I think a couple of years back, it was again in the news because the government of India, the present government, decided that, it wants to give this particular thing, the rights to 10 more agencies. So there was a lot of hue and cry on this because all these agencies can just go ask anybody for, for the decryption keys also. So this particular section, which is known as safeguard, monitoring and safeguards for interception, monitoring and decryption of information. So this is applicable all over, and any of these 10 agencies can go and ask the other company, whether it is Facebook, whether it's WhatsApp, whatever it is, whichever company it is, to provide that particular decryption. And because of this, this one thing also, India's is ranked amongst the top 5 surveillance states. So, because it's just not about only these 10 things. There are other things also. For example, our Aadhaar identification system. If you see, we are 1.23 billion people, and there is a biometric database over there. There have been breaches. The government has been in denial about it. I personally in 2017-18 did more than 30-40 shows on various news channels talking about the risk and all. But if you see, the entire thing is interlinked, whether it's your bank account, your purchases, your insurance, then other thing is we still don't have the data protection bill. And because we are talking so much about privacy, many people get confused that okay, we are going to have this data protection bill. Let's not forget, it's called as a personal data protection bill. It is not about personal data privacy bill. So we need to remember that. We don't need to get excited about it. Oh, we are going to have a PDPB, we're talking about. Guys, hold on. This is protection. It is protecting about your data. It's not at all protecting about privacy. I don't think so anybody really cares over here about anyone's privacy as such. Then again, the government has been after WhatsApp, asking it that they want to find the original sender. which means they'll have to break their encryption. So, you know, it's not that they are surveilling right now as far as WhatsApp messages are concerned, but that is their intention. Other thing, if you see like, okay, fine, you know, now we are coming up, especially down south, if you go, you're seeing a lot of like, you know, technologies being used, facial recognition, number plate recognitions. So yes, I think we are quite getting inspired by China, and somewhere we need to like slow down.
That's a great, Ritesh. Thanks for sharing those insights. I have one connected question, and maybe Jaipat could help me with this. Since Schrems 2 has been invalidated the privacy shield, and in large part of account of the perceived US government overreach under the US State Foreign Intelligence Surveillance and EO 12333, will this continue, Jaipat? Let me first stop sharing the slide.
Yeah, before I go to that, I was looking at that map which you had shown.
Oh, you really liked it? Thank you.
I liked it. It was right there. You would notice that GDPR has a preference for democracies. In fact, GDPR says it, that in so many words, that it is basically inducing European businesses to do business with democracies, where data is protected, privacy is protected, there is respect for human rights, there is respect for fundamental rights. So the opportunity that India has is tremendous. And the opportunity that countries like America have to continue to be relevant in this whole space is tremendous. This is reordering society as we know it. So the world map is being reordered. And so that's the first comment. The second comment I want to make before I go to 702 and 12333, Rajesh's comment about US cloud providers being everywhere. There is US everywhere, he said. So I was reading yesterday, Financial Times had a book review about cars, about the story of motion, that's what it says. And it said that the countries that ended up regulating car, the first ones were not Americans, because Americans were the ones who brought the car into public space the way nobody else did previously. So Americans were, and the car industry point of view was proliferating throughout the administration as well. So the first countries who came with regulation was to have mandatory insurance. And the first one to do that was the Scandinavian countries. So I think a similar thing is happening here as well. The Googles of the world, the Microsofts of the world, the Facebooks of the world are all in America. So it should not be any surprise that regulating them is coming not from America, but it is coming from a European jurisdiction where they do business, but they are not the sons of those countries. So that's a very interesting when you go back and see how regulation comes about. So same thing with 702 and 12333. I was reading a paper written by somebody who's sympathetic towards the US government. And he was saying that in the last 5 years, the Court of Justice took data from 2016 to invalidate Privacy Shield. That was 5 years ago, right? Now 12333 continues to remain in existence pretty much the way it was. FISA has been reauthorized. So to your question, 702 is very much in existence right now. But the interesting thing which he observed was that in the last 5 years, member states of the EU have done everything to learn these surveillance techniques from the United States so they can do it themselves. So
can't agree more.
So now, yes, that has been invalidated, and yes, we have this, and yes, we'll create another. They call it privacy shield. I call it privacy bubble. They will create another privacy bubble. they will make it very clear, which they have already done. In fact, Court of Justice has done. When it says do your own assessment, it is basically saying if you have been questioned, if there is a warrant cannery, announce it. Otherwise, go and have fun, do what you have to do. It's pretty much that. These are the standard contractual clauses which you sign. These are compliance requirements which you need to observe, or at least attempt to observe. And if you have not been questioned by US surveillance, go ahead and do it. After all, there is Article 49 allows that in the interest of governmental interest to have a place within the GDPR. So I guess the point is that even though 702 and 12333 continue to exist, to answer your question quickly, other jurisdictions are trying to replicate it. Other jurisdictions are more opaque. At our end, 702 processes have become very transparent today. We know that they go through a judicial process, a neutral judge, not like in the previous session, somebody was saying, the gentleman from TMT was saying, Malhotra, that it is the executive which decides who to search. That's not the case here. The final point I want to make is that this expectation that US citizens' rights would be similar, or the EU citizens' rights would be similar to US citizens' rights, that won't happen. That really won't happen. That is a constitutional question. And the idea that he should have, EU citizens should have the same kind of rights, that won't happen. Because the laws within the US are geared towards US citizens, whereas FISA 702 and 12333 are really geared to non-US persons for surveillance done outside the United States, principally. So those continue, and there is again some divergence and some convergence here. But they very much continue. And I would think that in some point in time, we'll find a meeting point. We will allow them to continue. There is going to be no constitutional amendment, but there might be a treaty, for instance, which will have a similar position as the regulations have. So this issue will die down at some point between US and Europe. And finally, there will continue to be data localization. So I think at a practical business level, data localization will become a very important thing.
Thanks, Jaipat. That was very insightful to share on these new nuances about US FISA and the executive order. My next question is to Rajesh. Rajesh, what are the different legal instruments which permit data transfer cross-border? Do we see the derogation under Article 49, the GDPR better way allowing for data transfers?
Yeah. So thanks, Kavitha. So before I step into it, I just wanted to compliment what Jaipat did mention, but still on the points also Ritesh did raise, I just wanted to show a little bit of a difference, in the way how we may have to look and approach this entire Schrems too. From Ritesh's point, data, it's understood. See, the Schrems to the overall surveillance, we do have several surveillance laws. We have from a criminal procedure code, we have the Telegraph Act, we have the IT Act, we have the SEBI, FISA, the FEMA. Every such requirements does have some portion of somewhere the surveillance. Now, the place and point where we may have to differentiate is between, one is at the citizen level, and one is what organizations do perform for clients as a data processor. And that's something which I'm seriously looking forward to the personal data protection bill, which is currently pending, where one of the sections excludes such data processors who are processing for clients totally outside the purview of the personal data protection bill. I wish to take that in a more optimistic approach Not to say that that is totally left out for the central government or the authority to have a different way of applicability. But I think that's a one way of approach that we have to look at it, and I see Schrems too majorly impacting at that point of time. Now, coming to Mr. Jaipat, see, every country has its own stemming national security concerns. I mean, even the CJU in the Schrems 2 ruling clearly says it is a country's responsibility to have appropriate surveillance, and no one is disputing that fact. I mean, Jaipat really touched on the sensitive issue. It's more about what is strictly necessary. So if I have a doubt on one particular individual, and instead of me targeting that individual, if I'm going to target the entire population, I think that's not strictly what is necessary. And if it is done in a manner which is not fair and it is not following the due process of law, the real place where privacy shield failed was the ombudsman or the arbitral process that was set. And that was the bigger difference between Safe Harbor 1.0 and Safe Harbor 2.0, which is the privacy shield, is that extension of right where a data subject gets to know that his data is misused or his data has been accessed in a way where he or she is not able to express or exercise his rights. I think that's where is the whole issue. And this is not going to, this is more of a political fiasco. Everybody understands it. We don't want to talk much about it. We know there's be a new privacy shield that will come, or a Safe Harbor 3.0 will come. And we also know the reality that there's going to be Schrems 3.0 will also come. So there is no doubt in that. So it's definitely going to continue there. So I just wanted to add that portion before on the instruments part, I think Aannaaand already touched base with that, and I also tried to identify in the previous questions. So basically, the adequacy is one of the instrument which only 14 countries in the world has the capability to apply it. And we all have the second one is the BCR, the Binding Corporate Rules, where organizations can approach the European Data Protection Board through a lead authority and get their applications filed and go through a rigorous process of 20 to 30 months long process, bill $500,000 as a revenue to law firms to cater the need of the administrative process. And you can get it. And I think we have around 200 to 300, not more than 300 organizations worldwide, which is BCR certified. The third approach is the standard contractual clauses, which is adopted by organizations worldwide. More than 99.9% is all this SEC. Derogations is one of the way, and I think recently one of the sitting judge of the CJU made the statement in some conference that was got the attention of a lot of people. I mean, the way how this particular derogations falls under some 2 or 3 criteria. There's a consent as a basis. You have something on the performance of a contract. Say, for example, I'm an e-commerce service provider, and as part of a service that is provided, somebody has to see the data for which the data has to go to another third country outside of EU. They can fall definitely under that particular scope. And then we also have the public interest mechanism and legitimate interest. So these are the 4 different, I hope I tried to cover all the derogations. So these are the 4 derogations through which you can do it. But there is a little bit of a challenge. Is it occasional or is it continuous? And to what extent of the data and what is the intent? Everything is a problem. And there are different methods, but depending on the nature and scope of a particular processing, derogations can also be a kind of a mode which can be proposed instead of choosing. Because one of the step in your 6-step process, which Aannaaand did, explain it, is to choose the right instrument. For example, in an employer-employee, you can't choose consent as a basis unless or until it is optional and there's a choice where the person is able to withdraw. Because when you use it, that instrument is totally wrong. It is incorrect. It is, I would say, not incorrect in the privacy world. It is illegal and unlawful, which would lead you to penalty, like the way how the Greece authority penalized one of the big 4 organizations. So this is how you need to. So you're choosing the right instrument is one of the most important thing that you need to do in order for you to demonstrate your accountability. And last but not the least, yes, data localization is going to be, and I think this data localization is stemming basically from concerns that are emanating from, I would suggest, where Ritesh plays more part is on the law enforcement authorities. I think that's where we will see. I mean, there's a Russian approach, you have the Chinese approach, different. You have some parts in Canada which have a very different approach. There are laws which prohibit public sectors to not allow the data outside of Canada. Whereas in Russia, you have a methodology where you can keep the main one copy there and the rest of the copy, so that tomorrow there's a law enforcement authority. If Ritesh wants to do an investigation, or a CBI has to do an investigation, there is an accessibility, because evolving laws, there are evolving regulation, technology. At the same time, the number of cyber crimes is also evolving. I think that this is typically a fight in balancing all this thing. This is my approach. And choosing a right instrument would be one of the organization's most difficult tasks. And as interpretation of GDPR is much wider and wider in role.
That was very insightful, Rajesh. Ritesh, we would definitely want to know your views on the data localization and breaches. But before coming to you, since Rajesh touched upon the SEC contractual clauses and the challenges, I wanted to understand from Aannand. Aannand, when it comes to the new SEC contractual terms, when it has guarantees and which is embedded within the document, including the data subjects as third-party beneficiaries, redressal mechanisms, indemnity, and liability. How are clients handling this? And are we going to see such requirement only in papers?
So let me answer that in two simple words. To your first question, how clients are handling this, I would say it's a burning issue, right? And to your second question, that are we going to see these requirements merely in paper? Probably time will tell. That's the simple answer I can give, because as of now, everybody is trying to attempt their privacy maturity model when they are giving the contractual guarantees. And it is not just the company to company, but the accountability is going to come from the supervisory authority as well as their liability towards the data subject. So no matter would you like it or don't like it, you will have to take this exercise, make sure that you achieve that particular maturity to some extent of your risk appetite, and make your business model also mature for that. So it has a kind of a very much cascading effects. And trust me, I will not restrict this particular question only to the EU part. You look at August 11, what happened? Abu Dhabi came up with their own standard contractual clauses. We have UK coming up with their standard contractual clauses. Now, imagine a situation where you are a privacy council or you are a privacy management team and you are working on all these things. You have to maintain a common intent of all these things into your maturity model and prove to your customer at the end of the day that your maturity model of privacy or the framework which you implemented is kind of ready to give us sufficient guarantees under this particular standard contractual clauses. Another simple line I would tag it as, it's like you're signing your own death warrant. Because the moment you sign these guarantees, you are abide by that. One single mistake by you or your service provider is going to put you on a spot. Secondly, this is not just the client and the service provider thing. You go to your vendor, you ask, like you just asked the question in the earlier forum, what happens with the small scale industries? Are they ready? Are they in a position to give such kind of a guarantee, even though it's a small industry? And is that guarantee sufficient based on the risk and the liability? So, like I said in an earlier conversation, that it's time will tell whether this is really, really sufficient. Yes, practically there is a lot of homework to be done before you get into a negotiation place. A lot of confirmation or third party audit which actually guarantees us that yes, we have achieved that maturity model where we have sufficient guarantees can be transferred to the customer. And that's where your question is absolutely right, that will it be merely on paper? So the answer is no, it shall not be merely on the paper. I know it's a tough exercise, but the truth is quite bitter. We have to accept, we have to work, we have to align our business with respect to these things, educate them in terms of what guarantees we are supposed to give, which is a requirement of law. I mean, somebody may call out, oh, these are just the guidelines. No, these are not just the guidelines. These are contractual guarantees which are in line with the requirement of law. So this should be taken very seriously, both by the privacy team as well as the business team to whom we are going to do the partnership. Again, nonetheless, CISO is one of the important function who is going to support us in terms of giving those guarantees, because those are the technical measures. If there is no adequacy test passed, like Rajesh said earlier, 14 countries, if you're beyond those 14 countries, that is also come into picture. So when you give those guarantees to anybody or even third party beneficiary, a lot of homework is required. That when you're going to sign that particular document, are you in proper shape? Are you in proper posture to give that particular guarantee? And then probably you should sign that guarantee, because just signing that merely on the face of it, just because SEC require it, it's a legal requirement. Trust me, if the data protection authority knocks your door, it's going to be a nightmare. It's going to be a nightmare. So that's my simple answer. Again, Rajesh, Jaipat, please feel free to pitch in, because it's a very tricky and very difficult question to answer. Because even if you go to a law firm and ask the external counsel to consult you, the external counsel is going to give you a big questionnaire that before I comment on this, you first tell me what is the position in your organization. And it is going to be a big task to investigate, to go back, rework on everything. And then, because see, the word is not the warranties, it is more of a guarantee, right? So it is more dangerous, I would call it as. So please, Rajesh and Jaipat.
External counsel is not asking those questions anymore, because the client never comes back.
On a lighter note, I just wanted to add, those organizations, exporters in EU, they are, but still we need to look at organizations with India who's having the presence also. They need to be mindful of data subjects, because in the new SCCs, the data subjects are added with third-party beneficiary rights.
Exactly.
Whom they have the right to seek a direct compensation, not just from the client, but also directly to the service provider.
Service providers.
The data is processing. He has access to the free copy of the SCC that you are executing as part of your commercial documentation. He has everything, and any failure would lead to huge problems. So this is typically, whether it is applied in practice, answer is yeah, that's what, as Aannaaand said, time will answer it. But be good to everyone. That's it, simple.
And just to add one point over here, Kavitha, as we have seen that whenever any country brings up the data subject rights into their legislation, you see a big chunk of volume comes to the organization, to the controller. What is my data, or where is my data? What's happening with it? Can I access it? And if it is not, there are certain watchdogs who kind of ready with their subpoena or a kind of a class action suit with the external counsel to go against your organization and fix it, right? So like it all tied with your reputation, your kind of framework, right approach to this particular thing, and how you are treating the data subjects at a world at a large, right? So it's a bigger picture to look at. And like I said earlier also, and Rajesh agreed to me, thanks Rajesh for that, that's time will tell this particular point, that how these SCCs are coming up in every jurisdiction, not just EU, but I would say every jurisdiction where they are bringing the SCCs, for that matter, in terms of data transfer.
Now that we are talking about data subject and data subjects as a third-party beneficiary, let me turn the table to India. Ritesh, recently we saw the largest data breaches by Domino's, Zomato, and Air India. Please let us know, how was it handled by the corporate and by authorities like CERT-In, and what right the data subject, that is the individual, has in these action, especially when they were impacted.
Ritesh, you're on mute. Ritesh.
You're on mute.
Yeah. So, Kavitha, if you see, some of them outrightly denied it. Some came up with the statement, but quite late. I mean, I think Air India came up with the statement, and somewhere I feel when Air India also came up with the statement, it was something that its parent company, not parent company, I mean, where it was like, you know, it had outsourced all its services. They forced it, okay, come on, you know, you got to tell everybody. But the thing is, if you see the breaches, I don't think so in India anybody is like really taking it very seriously, because there's nothing, you know, the concept of privacy is still not there. You know, everybody is like, and like even in my seminars, I always say that, you know, on internet, privacy, anonymity, and trust, these are the three things which are completely a myth. I mean, that's what my investigations are all about. You know, people like I was a part of MTV Troll Police, where I was an investigator, and you know, all these trolls, I caught around 60 trolls who were anonymously trolling celebs and other people. So this is what I always say, that anonymity, privacy, and trust are like complete myths over there. Now, even if you see Domino's completely like denied it, but if you look at the impact of it, like, you know, we got the data from the dark web, you know, a lot of sample data. In fact, that hacker created a small program also wherein I could just enter, let's say, Kavitha, your mobile number, and I would get how many times in the past 3 years you ordered pizzas. Where did you order them? I mean, I would get your addresses also, and I would also get your associated email ID. So just look at the risk. Now I am telling you on a lighter side. Let me give you an example. Imagine, Aannaand, I'm going to make you a scapegoat right now. Okay, please volunteer. You can't say no also. Okay, imagine Aannaand has ordered pizzas, and you know, his wife comes to me and says, I want to know where all Aannaand has ordered pizzas and all. You know, I will just put Aannand's number, and he'll say, oh yeah, it's in the office. Yeah, this is Aannand's office. Oh yes, this is Aannand's residence. This is our residence only. But what is this another address where he's been calling? Is he into some another relationship? You understand that? So that's a kind of one impact. I mean, just imagine what will happen to Aannand at that particular night. Okay. Now this is one thing. Now, if you see the other thing, we all, I'm sure, have received an email which generally goes into spam, which says that, you know, I'm a hacker, I have hacked your machine, and I've implanted a malware. And last night when you were watching pornography, I was actually also recording you. So there have been so many such calls I have got, because these emails are there. So these are what I call them. I mean, what is generally it's called as a sextortion scam. How did this happen? How did that guy send me? And you know why you tend to believe in it? Because in the subject, he says, this is your username and this is your password. And that is actually your password, which you had used on a particular platform. And now that platform was LinkedIn. Now on LinkedIn, the passwords were in clear text. I'm talking about some years back. So the email addresses were there, and in the clear text, your passwords were there. Now these guys got it. So we're just talking about the impact of the breach. So these guys got it. The hackers thought, okay, instead of me trying one email ID and password and trying to hack his Facebook or LinkedIn, let me do something like, you know, let me just create a script. He created a script. He just mass mailed to everybody, and in the subject automatically your password also came. So many people have paid that money in Bitcoins. I had at least 2 people telling me that we are suicidal. I remember somebody who was at a vice president level coming to my office. He's saying, if you're not going to save me, behind itself, there is a particular river, I'm going to go and jump over there. You know, it was so threatening. And I know how bad it was. So this is like the impact, and this is how hackers are also going. They're far ahead. I think whatever we are talking today is, you know, I know how hackers are going to like take it up, Kavitha.
On a lighter note, Ritesh, nobody can find the pizza details or address details of Aannaaand because of when he says, he will say Aannaaand, but the number of A's, it will not affect.
No, so I wanted to ask Aannaaand if this Aannaaand session sponsor is you. No, because if you add the characters of one Aannaaand and another Aannaaand, it will make that one Aannaaand spelling of yours originally.
Again, like I said, the test will prove what's right.
Great, good. See, I have a very long list of questions. I think we need to have one more session on this because there's so many new things that has come up with this new SEC. But before winding up, I just want each of you to, let us know what is the best practices to deal with this international transfer of data from your respective region. And maybe we'll first start with Jaipat.
So the lesson we have all learned is that data is not to be taken lightly. Data should be, where is it going? Who's handling it? How long it stays there? All of these things have to be constantly watched. So what GDPR, what EDPB, what the Court of Justice decision, what laws are coming everywhere, they are basically trying to say that, trying to mature us to a world where data is precious, data is private. So you have to go privacy by design, privacy by default. I think that mindset of privacy by design, privacy by default is what is thought to be inculcated through all these things. And there will be cases of some company being penalized in a very big way because they do want some poster, to be of a punishment so that it has a salutary effect on other companies. So this is going to continue. The second thing we should be mindful of is that government surveillance is going to continue. It is not going away. Private surveillance is taking place phenomenally. It's huge, at least in the United States. And like he said, this is also a surveillance, trying to find out where Aannand's pizzas are going. So this is not going away. This is not going away. So this is the second new reality we have to accept. I think the third reality is that the power of media, is social media, intermediaries is going to be huge. It is going to manipulate us. We will have to be very careful of how we deal with them. There is a plus side to it and there is a minus side to it.
Great. Thanks, Jaipat. Rajesh, next you.
Okay, so for me, handling data transfers, I think most important thing is, see, whether it is transfer or anything, what you contractually agree as an organization, you are supposed to be bound by that. Take compliance as one of your key performance requirement, that every individual who is handling data should be responsible the way it is to be handled. Because of privacy, when you look at privacy as a topic, it is unique, and it is what is private for me may not be the same for you, but for a different person it can have a different applicability. We need to be very cautious and understand our culture is different, so I think it is going to take a big roadway. And we can literally see when you try to talk to conversations in Europe, and when you say you're from India, the next thing they say is, we can't trust you. I mean, that's a fact. In Europeans, if you wanted to do recruit a particular candidate, and if he's giving us a disclosure that this is his information, even from him, if you have to take a reference check, you don't take a reference check, because when you do that, you are not trusting that particular person. I mean, there's a kind of benefit that needs to be extended, and that's how the privacy as a culture is treated in EU as well as in other parts of the country. I like FTC's approach. I mean, FTC tried a lot of approaches. It used consent as one of the approach. I think now FTC follows the harm-based approach. That is, in the sense, like, as long as whatever you do, you practice, as long as you don't create a harm to the data subjects and make sure that you respect this individual's rights. Good. I think that's a kind of a thing. So know what your data, what you are transferring, and make sure that you be mindful in terms of trying to have an inventory so that you know what you are actually dealing with it. I think that should be one that probably organizations needs to plan. I mean, I don't want to call which department has to manage it because that's subjected to each entity and each entity's organization's risk appetite. I don't want to create that kind of a debate over this on that topic. But I think that's more basic. So you need to respect each employee should take equal accountability and responsibility while handling such data, and comply with the requirements that what you have agreed, and that's a promise that you have made in the contract, and you need to live with it. So please be mindful of that. So it should not be just in paper. So this is what I would say. As long as we do that, any transfer document or any documents that you might talk, either in an MSC form or an SEC form, I don't see there is any kind of a difference that may fall apart.
Great.
I'm just looking at.
Thanks, Rajesh. Over to you, Aannaand.
Yeah. So
quickly on the key takeaways.
Absolutely. I'll be very quick. So one thing is very clear that our privacy maturity model has to be improved. It's a constant thing. It's not one-time thing. You have to also look into what framework you're going to select to improvise that every time. You have to monitor all the laws before you give any kind of a guarantees through your contractual obligations to anyone. And last but not the least, you have to keep yourself auditing, because your third party management program, which is managing your vendors, their sub processors, needs to be so strong that when you kind of sign any kind of a contractual guarantees, representation, warranties at that place, you have to be confident enough with your risk appetite that what risks you are contractually agreeing to, not only just to the customer, but like Rajesh said, it's also to be the data subjects and to the third parties, which are also the regulators, to promote that what kind of organization you are. Are you really privacy sensitive organization, right? So that way, I think that's the key takeaway I would just call it as.
Great. Ritesh?
Practice the principles of data minimization. That's something that's very, very important. At least anonymize the data or pseudonymize it. And lastly, don't forget about the man in the middle, the man in the middle hack. So those attackers are always there, because when you're doing a data, these data transfers, that is the time like we need to be like really, really very careful about it. That's it from me.
Thanks,
Hey,
Kavitha. I would like to thank Jaipat for.
Kavitha, one interjection from hearing these luminaries. In meditation, we say, watch your breath. I'm getting the message, watch your data.
Good one, very good one, Jaipat. Thank you so much. I wanted to thank you especially for joining us at a very early morning your time, and it means a lot to us. And thanks to everyone for driving us deep into the Schrems 2. Over to you, Prajakta.